Good morning, good afternoon, good evening, and thank you for joining us today. My name is Priya Pillai, and on behalf of the International Commission of Jurists and the Asia Justice Coalition, it is my pleasure to welcome you to the webinar on Crimes Against Humanity Convention at the UN General Assembly 6th Committee, the potential and relevance for Asia. Some context before we start this important discussion. In 2019, the International Law Commission submitted the final version of the draft articles on crimes against humanity to the UN General Assembly, based on the work done by the Special Rapporteur at the ILC, Professor Sean Murphy. Since then, the draft articles have continued to be discussed, and further actions were deferred at the 6th Committee, which is the primary legal forum of the UN General Assembly. In November 2022, a cross-regional group led by Mexico and the Gambia proposed a resolution co-sponsored by 86 states, establishing a 2-year timeframe for the discussion on the ILC draft articles and to recommend the elaboration of a convention by the General Assembly or by an international conference of plenipotentiaries. Based on this, the first resumed session of the 6th Committee took place from 10 to 14th April of this year, which witnessed active participation on matters of process and substance relating to the ILC draft articles. In October of this year, states will revisit these articles at the 6th Committee and have till the end of 2023 for written submissions. Thereafter, the second resumed session on the articles will take place in April 2024. Against this background, it is imperative to examine the relevance and the potential of an international treaty on crimes against humanity for Asia. This region is not a stranger to the commission of such international crimes. Unfortunately, we need only look as far as Myanmar as an example, with the commission of such crimes at this very moment, or Afghanistan or the Philippines. As part of this timely discussion, I would like to introduce our 4 eminent experts from the region with us today. Judge Kriangsak Kittichaisaree, a sitting member of the International Tribunal of the Law of the Sea and a former member of the International Law Commission, who has actively participated in the deliberations on the ILC draft articles. Dr. Chia Wei-ling, Associate Professor, Faculty of Law, National University, Singapore. Judge Maria Natercia Guzmao Pereira, former President of the Court of Appeals, Timor-Leste, and former Judge of the Special Panels for Serious Crimes, East Timor. And Professor Kingsley Abbott, Director, the Institute of Commonwealth Studies, University of London, and former Director of Global Accountability at the International Commission of Jurists. Before ending these remarks, a word to our online audience. Please feel free to put your questions in the Q&A. And if you have questions for a particular speaker, please indicate that. We will take up some audience questions after initial reflections from our panel. Thank you for that, Kingsley. I think, what's really jumped out to me from your comments was this phrase, a comprehensive legal framework. And I think that sort of encapsulates, a lot of the discussion that we have, including around different other international treaties, sort of the relevance, the pros and cons, and that this would provide a framework at the domestic level as well. And I think to your point, that's a key advocacy point for many of us as well, in how we approach the discussions around this treaty going forward. So thank you very much for that. We've had one round of questions, but I still have more questions for our panelists. So I think what we'll do is we'll do another set of questions very targeted for our panel, and then we're going to have questions from the floor. So we'll stick with the same order. Judge Kittichaisaree, I'm going to come back to you right now. Again, just to sort of delve a little bit more on your experience at the ILC, and of course, as much as you can tell us, but on the last UNGA 6th Committee session in April this year, I would love to hear more about your sort of perspectives, what you thought of the positions of Asian states. Of course, you've given us the caveat that, many states have a very blanket or broad approach to this, but if you have some insight, that would be very, very helpful, I think, for us.
Thank you very much. I think you look at the records of the discussion in the 6th Committee last April. India said that Crime Against Humanity Convention is not urgent. It's enough to have the so-called territorial and active personality jurisdiction. And you look at Indonesia and Philippines, both of them say that the existing law are consistent with crime against humanity definition. under the proposed convention. But my question is, with due respect, would existing law in Indonesia, for example, cover the so-called alleged crime against humanity in West Papua? And would existing law in Philippines cover what the ICC is trying to do in the Philippines, that is trying to investigate the so-called crime against humanity in the context of extrajudicial killing or the war on drugs? And then we have Sri Lanka, who argues that definitions of extermination under the draft convention is too wide, it violates the principle of legality. And the definition proposed by Sri Lanka would exclude, with due respect, the so-called the war against the Tamil, the civil war in 2009, especially the controversy regarding the action by the Sri Lanka military at that time. So in other words, we have seen the so-called willingness as well as the so-called trying to interpret the draft convention to suit their own domestic situation, to exclude the possibility. And I was struck by what Kingsley said. You look at the record of how Asian states become parties to the relevant treaties, and you look at, for example, the Convention on Enforced Disappearance. Enforced disappearance is a crime against humanity. This convention has 71 parties. Only 10 are from Asia. And the most interesting that what struck me is that of the 10, South Korea, which has become party to the Rome Statute from the start, was able to accede to Enforced Disappearance Convention only in January of this year. Because of the situation about the military regime in the past. So this is a sensitive issue. And you look at the Convention Against Torture, many big names in Asia are party to that convention. And you look at very basic convention, ICCPR, right? The convention that somehow lays down the basic guarantee of human rights. And we see many big names in Asia, China, Singapore, Malaysia, etc., which are not party to this convention. Myanmar not. So, and then, from my experience negotiating the elements of crimes or the Rome Statute, one thing that has to be borne in mind, several conservative Muslim majority states in Asia cannot accept criminalizations of what they call cultural and religious practice. The specific concern enslavement, sexual slavery, inhuman act, and persecution. So during the drafting of the elements of crime for crimes against humanity, I was the head Thai delegation at that time, try to strike compromise to accommodate the concern of Muslim countries. And it is clear in the introduction, that is chapter to elements of crime against humanity in paragraph 1 and 3, which reads that, I try to, okay. It says that conduct which is impermissible under generally applicable international law as recognized by the principal legal system of the world. So crime against humanity must be conduct which is not permissible under generally applicable international law, as recognized by the principal legal system of the world. that is for country applying Sharia Islam. And then paragraph 3 of that chapter also reads, an attack against civilian populations, deliberate failure to take action, which is consciously aimed at encouraging an attack directed against civilian populations. In other words, Muslim majority governments doing nothing is not tantamount to condoning widespread or systematic attack against civilian population. The government concerned must consciously, deliberately fail to take action, which is consciously aimed at encouraging crime against humanity. You see, this thing has been overlooked by those trying to convince Muslim majority state to assure them that, you look, we try very best, our best to try to safeguard your cultural and religious practice. But you still have a long way to go, because just like the issue of enslavement, sexual slavery, and persecution on basis of gender or nationality is still major concern in Muslim majority countries. Thank you.
Thank you, Judge, for your comments. I mean, I think the few things that I've pulled out from your remarks, first is, I think, just that a lot of states in Asia are recalcitrant. I mean, we have enforced disappearances, torture convention, ICCPR, many that are just not signed up to. And so we have, to Kingsley's point earlier, we have the need for this legal framework and the need for something within the domestic framework as well that I think we can draw upon. And I think the second point that you raised, and I know that we have colleagues who are working on this quite a lot, is sort of a gender analysis of the crimes against humanity draft articles. And I think that's going to be a big discussion, as it should be moving forward. And just to indicate that, you know, I think ICJ and Amnesty have also come out with a recent report just as of last week or a week and a half ago on Afghanistan and crimes against humanity of persecution, gender persecution. So I think, again, there are a lot of these discussions that perhaps we can refine in this treaty discussion moving forward. But I think without further ado, I'll come to Dr. Chia. And, you know, I think to focus a little bit more on the ASEAN region. And if you could tell us a bit more with the atrocity crimes framework within ASEAN and how you think crimes against humanity, you know, the draft could benefit ASEAN as a region.
So thank you very much for that question, Dr. Pillai. So ASEAN comprises 10, soon to be 11 member states: Brunei, Cambodia, Indonesia, Laos, Malaysia, Myanmar, Philippines, Singapore, Thailand, Vietnam, 11 right now, with Timor-Leste's in principle acceptance of membership. And currently, there is no strong atrocity crimes framework at the regional level. So as Judge has pointed out, only 2 countries in the region, Cambodia and Timor-Leste, are member states of the ICC. However, this does not mean that states in this region do not engage with atrocity crimes at the international or domestic level. And they all recognize the importance and legitimacy of these crimes, that these crimes are actually criminalized. And there is, of course, a need for such engagement given the ongoing Myanmar conflict, which demonstrates that the region is not immune to such conflicts and justice questions. So in brief, countries in this region have taken diverse approaches when engaging with atrocity crimes at the international and domestic level. And there's really a need, I believe, for more regional coordination, given the fact that investigating and prosecuting such atrocity crimes on such scale requires cross-border cooperation. So in terms of international instruments, as Judge said, so ASEAN countries have ratified selected but pretty few atrocity crime treaties, such as the 1949 Geneva Conventions and the Torture Convention, as well as the Genocide Convention. I won't go through the various countries in the interest of time. And some countries specifically criminalize atrocity crimes in their penal codes alongside other crimes. So for example, Timor-Leste's penal code criminalizes genocide, crimes against humanity, and war crimes, enslavement, and torture. And Article 8 of the Penal Code further states that Timorese criminal law applies to these acts committed outside of national territory if they constitute atrocity crimes, as long as the perpetrator is found in Timor-Leste and cannot be extradited or a decision has been made not to do so. Other countries in the region adopt specific laws dealing with atrocity crimes. so specific laws separate from their penal codes. An example would be the Philippines. The country's Crimes Against International Law Act 2009 criminalizes war crimes, other crimes against humanity, and genocide. And it also recognizes certain jurisdictional grounds, including the accused regardless of citizenship or residence when he's present in the Philippines. And this law also foresees overlapping jurisdiction by recognizing that in the interest of justice, the Philippine authorities may dispense with the investigation or prosecution if another court or international tribunal is already conducting the investigation or undertaking the prosecution of such crimes. Now, Indonesia is an interesting example of a country that has criminalized atrocity crimes in specialized law as well as in its to-be-implemented new penal code. So the specialized law number 26 of 2000, sets out the composition and competence of Indonesia's human rights courts, which are supposed to examine and judge cases of massive human rights violations referred to, which are defined as genocide and crimes against humanity. And however, Article 5 does state that these courts are authorized to deal with cases of massive human rights violations committed by Indonesian citizens beyond the border of Indonesia. And the jurisdiction is therefore based on territoriality and nationality principles. A recent petition to Indonesia's Constitutional Court to amend this law to authorize universal jurisdiction was denied. But very interestingly, the Constitutional Court did recognize the importance and legitimacy of universal jurisdiction and the need for more regional efforts. It should be noted also that Indonesia's Dewan Perwakilan Rakyat has passed a bill creating a new penal code to enter into force in 3 years. And Article 6 appears to recognize universal jurisdiction for certain crimes, several atrocity crimes, including torture, genocide, and crimes against humanity. So it's not clear how the new penal code will actually interact with law number 26 of 2000. So in brief, while Southeast Asian countries have not ignored or rejected the idea of atrocity crimes, engaging with these crimes at the international and domestic level, these countries have generally taken an individualized approach, and there's need for more coordination at the regional level, given these countries' familiarity with the region's context and needs.
Thank you very much for that. I mean, I think that was really illuminating in terms of what is happening at the domestic level across ASEAN and potentially the hooks that we might have to see sort of universal jurisdiction developing a bit more. And perhaps the Crimes Against Humanity Treaty, as and when it does evolve, and if it is adopted within these states, might give that additional push to actually UJ cases as well within the region. So I think potential areas for more research definitely arising from this. I think we'll now come to Judge Pereira, and sort of I would like to talk a little bit about your experience at the special panel. And, if you could share with us your expertise, what it took in terms of capacity and the support that is required for investigation and prosecution of crimes against humanity domestically and in these hybrid tribunals.
Yes, there were resource issues faced by, Yes, there were resource issues faced by special panel, and also the serious crimes unit, which was the prosecution office. Our work must be recognized and commended because despite these issues, more than 75 individuals were indicted by prosecutors, including very senior level perpetrators. The case concerned all 13 districts, and we had issued judgment in 55 cases within a period of less than 5 years. To prosecute crimes against humanity domestically, national laws must incorporate the substantive crimes, which are defined in accordance with a Rome Statute. And it must also incorporate rules of evidence and procedure that will enable effective prosecutions, particularly with reference to sexual and gender-based crimes. National law must ensure that provisions are gender neutral and incorporate a broad definition to what amounts to sexual crimes and also consider persecution on this base of gender. Corroboration is mandatory for some countries. Yeah, sorry. Some countries. This can be very when prosecuting crimes against humanity for many reasons. Yeah. An effective witness support and protection system is important as well. I also want to stress that when we prosecute this case, we must make sure that the culture and traditions of a country are considered part and parcel of the cases. We must culturally sensitive approaches, which is encourage victims to trust and participate effectively. In many of the cases I presided in, being a Timorese judge, I was able to give direction on how to make my courtroom victim friendly. We need to understand the culture if we want to know what is barriers to witnesses and victims come forward and to tell their story without shame. Training of national prosecutors, defense lawyers, police, and judge on investigating, prosecuting crimes against humanity is needed. For example, there is now a great focus on open source evidence. I think we need to be trained on this matter. Yeah. Thank you, Doctor.
Thank you, Judge. I mean, I think that was a really critical sort of, I think, reality check for many of us in terms of implementation. What happens next? Once you do have a crimes against humanity treaty, once you do look at incorporation into domestic law, then what? What do we need to do to actually make it a reality that you can prosecute, that you can, have accountability for those crimes? So I think thank you for reminding us of all the incredible steps that need to happen even after a convention comes into place, and for the actualization of these rights within a domestic system. I'll now turn to Professor Abbott, sort of for the last structured question, and then we're opening the floor. But I think just to ask you, as a regional and an international justice expert, how do you see sort of the positioning of Asian states at the upcoming Sixth Committee sessions, in October as well as in April?
I think when, as you've described, Priya, there's still a lot of opportunity for advocacy with Asian states, because there's still a lot of moments for them to take positions and provide input. And so I think that what position states will take will depend a lot on civil society engagement and advocacy around what positions should be taken. And, when I look at the past positions that Asian states have taken, I was, pleasantly surprised to see that it wasn't all negative. In fact, states like Korea, Thailand, Bangladesh, Japan have been overall generally positive about the need for at least a process to examine a treaty and for its potential utility. And then when I look at some states which have taken a more negative and critical approach, and I think we already heard, say, some of the statements of India in the past, for example, their reasoning behind it was, do we need another treaty in this space? Isn't the Rome Statute already sufficient? Isn't this in some way duplicative? Which goes to show that, in some cases where Asian states may previously have demonstrated that they may continue a somewhat neutral or negative position, it may be based on a misunderstanding around the exact role and purpose and function that a Crimes Against Humanity treaty would play, and therefore there's an opportunity to engage, talking around why it's necessary, why it in fact is something that would emphasize more national processes and regional cooperations than some sort of vertical relationship with, say, the ICC or something else. So I think the last point I would make is that this is a really ripe opportunity, I think, for civil society in the region to look at how they can shape and influence what position Asian states will take. It's certainly not something that is already locked in and predetermined. I think people would agree. And I think most importantly, hearing from my colleagues, who attended the recent negotiations around the MLA treaty, there is, I think, what people came away with. They really saw, look, it's really important that regional groups like Asia, like states in Asia, do engage in these international negotiations around similar such treaties. And not only that, there's a real opportunity for them to take strong leadership positions to avoid a treaty that may, reflect a very global North perspective or may address issues that are mostly unique to, say, Europe or the US. What's important, I think, if a treaty like this is to be developed, then of course it needs to be consistent with international law and standards. It needs to fit firmly within a logical and comprehensive international legal framework, but it also needs to be useful and applicable to regions such as Asia. So I would strongly encourage civil society to rally around and develop a really strong advocacy strategy to ensure that Asian states, A, engage in this process, 2, engage meaningfully, and 3, really potentially take up a leadership position in these discussions.
Thank you for that. I mean, I think that's really critical as we go into these next few months as well, to keep that in mind. And as one of the people that was in the room in Slovenia during the MLA discussions, this month, I can only re-emphasize your point, which is, I think, the need for Asian states to engage. We saw very few in the room during the MLA discussions, but I think also, to highlight the need for civil society to really engage and rally around and make sure that we are well versed with all the discussion points, as Kingsley has pointed out, sort of the arguments that might come up against the treaty, which may be rooted in misunderstandings as well. So I think there's a need also for really cohesive front on the part of civil society, academia, researchers as well, to ensure that this pushes through. And I think with that, we'll come to some of the questions that we have from the floor. So I already have a few in front of me that I will put to particular speakers. I think we have one, and I'll start off, going back full circle to Judge Kittichaisaree. We have a question from Hugo Relva from Amnesty International, who says, a few days ago, a diplomatic conference adopted a new convention on cooperation on genocide, crimes against humanity, and war crimes. It contains an aut dedere aut judicare for all these crimes, which exponentially expands the jurisdiction of state parties and implies universal jurisdiction. It would be interesting to hear from Judge Kittichaisaree as an expert on this issue, and to discuss more about whether this convention will enhance the practice of universal jurisdiction. Judge, this is
thank you very much. Hugo, nice to hear you. He's a good friend of mine. But you see, you look at the record of the states that support the so-called mutual legal assistance treaty. As of the 5th of April this year, the initiative was supported by 29 states, only 4 of which are from Asia. That is Kazakhstan, Mongolia, Samoa, and Vietnam. So you asked me whether the obligation to extradite or prosecute under the new treaty would somehow support universal jurisdiction. The answer is support universal jurisdiction to the extent that the state concerned are party to that treaty. Look closely at the opinion of ICJ President Gilbert Guillaume in the arrest warrant case in 2002, he said very clearly that if you extradite or prosecute according to treaties, this is not universal jurisdiction. It is treaty-based jurisdiction. So you have to be very careful. In other words, it will not transform itself into customary international legal obligations of the obligation to exercise universal jurisdiction, but it will somehow obligate state parties to the new treaty to establish jurisdiction to prosecute or extradite. Thank you.
Thank you for that, Judge. And I'd like to sort of follow this up, given Dr. Chia's sort of focus on universal jurisdiction and what she's also told us. I think I would like to hear a little bit from you in terms of whether you think this treaty process, CAH, would make way for universal jurisdiction, and how does it sit also with the non-interference principle that is sort of sacrosanct for ASEAN?
So thank you for that really important question, Dr. Pillai. So as I mentioned earlier on, ASEAN states have recognized the importance of universal jurisdiction, especially before the 6th Committee's discussion on the topic. They also recognize the challenges. And ASEAN states are often criticized for adhering very closely to the principle of non-interference. But an alternative take, when you look closely at the discussions, is that when you look at the concerns raised when it comes to universal jurisdiction, you could kind of understand it from a rule of law perspective. So the concerns largely relate to the uncertainty over the scope and content of universal jurisdiction, instead of citing the principle of non-interference. So a crimes against humanity treaty could make way for universal jurisdiction by enhancing certainty over the definition of this crime as well as the seriousness, encouraging more acceptance of crimes against humanity as an atrocity crime, attracting universal jurisdiction even under customary international law. So if you look at the discussions at the 6th Committee on Universal Jurisdiction, ASEAN states have recognized genocide and piracy as classic crimes attracting universal jurisdiction, but not so much crimes against humanity. And I think that this is one way a treaty on crimes against humanity could add to and make way for universal jurisdiction. And also, could I just build on the points made so far by other speakers on the importance and the need for ASEAN states to engage? And why not make a submission as a regional grouping before the 6th Committee and build on ASEAN's existing work relating to cross-border cooperation in criminal matters, such as the ASEAN Treaty on Mutual Legal Assistance? When engaging in these discussions, ASEAN states should not also hesitate to give concrete suggestions that go beyond general principles. So, for example, several ASEAN states argued in their statements in the 6th Committee that universal jurisdiction should only be exercised as a last resort based on the subsidiarity idea. Strictly speaking, international law doesn't recognize any hierarchy or priority, but some states have implemented subsidiarity as a matter of policy, and Vietnam put forward a quite precise proposal. Some guidelines regarding the exercise of universal jurisdiction, complementary, that was a phrase used, to other states with a stronger link to the crime, such as a territorial state. So Vietnam suggested that first, universal jurisdiction may only be exercised if the accused is in the territory of the state wishing to exercise such jurisdiction. And second, the state wishing to exercise such jurisdiction should consult with the territorial state and nationality state about the possibility of extraditing the accused. So such detailed interventions move the discussion forward and can enable ASEAN as a region and ASEAN states to take a leadership role.
Thank you for that. I mean, I think there's so many ideas in that we can carry forward as well. So we'll be coming back to you, that's for sure. I think the next question is for Professor Abbott, and this is Tess Graham from the Global Justice Center. No, my apologies, Melissa from the Australian Centre for International Justice. What are the specific aspects of a draft Crimes Against Humanity treaty that you think might be most important for civil society organizations to advocate about? How can civil society advocacy be most effective in persuading states to support these aspects of the treaty and ultimately support the adoption of the treaty?
Thanks, Priya. I think one of the real challenges for civil society at the moment and across Asia, knowing that there's also a lot of diversity across Asia, from South Asia to ASEAN and East Asia, is to really develop an advocacy strategy. And I think it's going to be really important first to identify the goal of that strategy. Widespread support for a treaty in Asia that conforms with international law and standards, and then also universal adoption. And I think it'll be important for civil society themselves, victims groups, those who've been working on atrocity, crime prevention and accountability, in some cases for decades, to identify themselves what they think the priorities are. Is it around definition? Is it about cooperation? Is it about encouraging investigations and prosecutions? Is it around the obligation to extradite or prosecute to sort of close this accountability gap to ensure that perpetrators can't find refuge in a country where they are, not going to be subject to a prosecution or investigation or even extradition? And I think that, you could look at the challenges, you could go state by state, region by region, sub-region by sub-region. But I think what's going to be important is to identify, which possible champions, state champions in the region can you really focus on? Is there a state in ASEAN that's really going to pick up this and coordinate other ASEAN states, likewise in South Asia, East Asia? And I think, interestingly, also for other states that may, you think, be less willing to engage or less supportive, identify why that is, what the obstacles are. If some of the past statements of states are anything to go on, like we've heard, it may sometimes just be a misunderstanding about the aims and purposes of the treaty. And I think it's going to be really important to focus when engaging with states in advocacy on the fact that this treaty is really also focused on justice at the national level, at the domestic level. It's focused on regional cooperation. And lastly, as we all know, it's important as a foreign policy reality to identify what's going to be in a state's self-interest, what's going to be in their interests. Is it, maybe some states are looking for an opportunity to make a powerful foreign policy statement at this time. Maybe some states have made statements around being very committed to stronger rule of law or a stronger legal system nationally, solidarity with victims and that kind of thing. But I think this is a really important opportunity, a moment for civil society, for themselves to identify what their priorities are, who their state champions are going to be that they'll target, and then come up with a campaign around maybe dispelling some of the misunderstandings about the aims and purposes of the treaty.
Thank you for that, Kingsley. And again, we'll certainly be coming back to you for more discussions along these lines. And I think the last question is for Judge Pereira. And, we've had President Ramos Horta, who's taken a public stand against the military coup in Myanmar and has called to uphold democracy. Do you think a new Crimes Against Humanity treaty could reignite the conversation about the importance of international law and an end to impunity in the region? So, Judge Pereira.
Okay, thank you. Yeah, recently President Horta's calls for accountability and end to the impunity of crimes taking place in Myanmar is a testament to Timor-Leste commitment to the justice, and no matter where injustice is happening. We know the importance of accountability, and we are living proof of that importance of holding perpetrator accountable, and to the fact that justice at home is the best form of justice. The new Crimes Against Humanity treaty will only be a conversation starter in our region if we see its relevance to us. You cannot just engage Asia to take interest in a treaty, which we may see as well only applicable to crimes taking place in Ukraine and Sudan. Yeah, thank you for holding this event and for inviting me as a panelist with the distinguished judge and other panelists. We need more public events like this and the involvement of the people like us who have worked nationally on these cases, and to create the awareness in our region. And to answer questions based on our personal experience. The conversation needs to take place at the ground level, and everyone needs to be aware of the needs and effect of these crimes against humanity treaty. You saw what happened when it is come to Malaysia signing the Rome Statute. I followed some of the discussion in the news. I would have suggested that during that period, Malaysia should have engaged with other countries in the region who are state parties to know how it has impacted us. I think this treaty will be more encouraging as it is about national ownership of accountability. And we elevate any concern that international accountability is a threat to national sovereignty. Yes, I think, Doctor, that's I would like to say.
Thank you very much for that, Judge Pereira. I mean, I think to exactly what you said, this is a conversation starter, I think, for a longer journey in terms of a sort of national reckoning for crimes against humanity and sort of accountability across the board. Unfortunately, we are exactly on time. We are 1 hour to the minute, and we have to stop this webinar at this point. But, just to say thank you very much to all our panelists. It's been such an enriching discussion. It's the first of many initiatives to center Asia and voices within the region in the larger international justice and accountability architecture. We will also continue to engage and monitor movement on the ILC draft articles. Please do follow the Asia Justice Coalition and the International Commission of Jurists to remain updated. Once again, thank you very much to our panelists for this absolutely enriching discussion. We will definitely have more of these events, and this is just a conversation starter, as Judge Pereira has said. Just thank you very much also to all of those who have logged on, taken time to listen to this webinar, and we will be sure to sort of keep you involved in the discussion and look forward to many such events. So thank you very much, everybody, and take care.